Thanks very much for having us. As Susan said, I'm Ben Barnes, and this is my partner, Catherine Hansard. Some of you may have seen this, some of you may not have. I was very excited when the Texas legislature passed a law recently that creates a Texas business court. Now, I'm going to admit I'm a little bit of a litigation nerd, so to speak, given my background and my practice area of focus. But what we're going to focus on during our presentation is we're going to take you through just an introduction to the business courts, what they are, and then talk about how we expect the courts to function. They're not going to begin operating until next fall, but even from a transactional perspective, it's something to get up to speed with in terms of what we expect the courts to look like and how we expect them to function. And so I'll give you an introduction to that. Once I get through my introduction of the courts and their attributes, I'll turn it over to Catherine, who will tell you why you should care if your practice is primarily transactional. And we'll use it to segue into a couple of classic drafting issues that always come up and are always important, especially from my perspective as a trial lawyer, but are not always the focus of commercial folks leading deals. But we'll talk through how this impacts those standard contract provisions, including your dispute resolution provisions and your form selection provisions in your basic corporate agreements. So first, what are the business courts? So it's hard for me to have perspective on this because this is right in my lane. So everybody in my world has been talking about this, but if you haven't heard about the Texas business courts, essentially the state legislature enacted two laws in June. One of them creates a trial court oriented towards resolving complex commercial disputes. And I think the motivation here has several things driving it, but one thing is that we have great judges in our courts of general jurisdiction across the state in our major cities, Dallas, Houston, San Antonio, et cetera. But one of the problems that those judges have is that they have a very diverse docket of civil matters. Their dockets include not only the commercial disputes that you and your clients may become involved in or that folks like I tend to work on, but they also have a pretty high volume of cases that involve personal injury, like car wreck cases, premises liability, things like that. And then there's also a substantial kind of debt collection and mortgage foreclosure cases of those flavors. There's a substantial amount of those cases that happen, particularly in our major cities. And so I say all that to say is that even though we have great judges in our courts of general jurisdiction, they're incredibly overworked. And unlike federal judges who are well-staffed and have dedicated assistants and clerks of highly qualified new law graduates, our state judges don't have the funding for that. So I think one of the motivations behind creating this business trial court was to take the workload off a little bit of these courts of general jurisdiction, particularly for these complex cases that present issues that those judges are not used to dealing with. So imagine those of you who have been involved in litigation and multi-million-dollar litigation. You may have a great judge in Dallas County or Harris County. If you've gone into a courtroom for a hearing in those cases for a motion to compel or some significant to hear an issue about some significant privilege issue or for a big and impactful motion for summary judgment, you may have observed that the hearings before and after you have a completely different flavor. And it's really hard, I think it would be hard for judges to jump between, issues that are related to kind of the run-of-the-mill personal injury cases that are very mechanical and formulaic, and then having to focus on the complex disputes that I think most of you and your clients tend to become involved in. So that's one of the drivers behind creating these business courts, was to sort of create a new set of judges that could take that load off courts who are having to deal with a lot of other issues. And then the idea is to provide judges who are focused and adept at handling these complex issues. I think one of the other drivers behind it was the focus among the Texas government and the legislature into making Texas a very business-friendly place. So I know, even though I'm a Texas lawyer, I pride myself in being a Texas lawyer, that a lot of high-profile and impactful disputes that involve my clients, even if they're Texas-based clients, are actually happen in the Delaware Court of Chancery, right? And I think that there was some thinking among the legal community and among the Texas legislature, why aren't we competing for this court business, given that Texas is the safe place for business that it is, right? So I think that's kind of what was driving behind it. And again, just kind of ticking through what we have on the slide here. So what I've been talking about is the business court, the trial court level is what I've been focusing on. Specialized judges to handle these issues that have better resources and are more able to devote time to complex disputes than are judges who oversee courts of general jurisdiction. Secondly, the legislature also passed a statute that creates a new court of appeals. So Texas currently has 14 courts of appeals modeled after the federal circuit courts of appeals, and that each court of appeals has a specific geographic jurisdiction. This new 15th Court of Appeals would sit in Austin, and it would take appeals from the newly created business court. And I think the same motivations are behind this. We want judges who are able to devote time and who have specialization to give whatever complex business disputes that are happening in our state the attention that they deserve. And the same reasoning, I think, applied behind the creation of the Court of Appeals. Now, what's interesting about the 15th Court of Appeals is that it also will serve as a specialized court to hear administrative matters, appeals from Texas-based administrative agencies. So the way our appellate system is currently set up is if we have an issue that's being appealed directly from an administrative decision, those issues are typically directed to the Third Court of Appeals, which geographically covers Travis County, which makes sense because it's the seat of government. So I think of the Third Court of Appeals now as almost like a DC circuit. On the federal level, the DC circuit handles all administrative appeals and deals with administrative issues. I think of the Third Court of Appeals in Texas as sort of a DC circuit. But unlike the DC circuit in the federal system, who doesn't also have to deal with all of the commercial and criminal disputes that arise in its area of jurisdiction, the Third Court of Appeals has to do the job of a normal court of appeals as well. So they included this administrative role for the 15th Court of Appeals as well that would allow judges to specialize in those issues and take it off the plate of the Third Court of Appeals, so to speak. And as I mentioned, these courts will, the enabling legislation provides that both courts will begin operating next fall. So while there's been a lot of people writing about this and talking about this, it's a little bit hypothetical in the sense that we don't actually know how these courts are going to look and how they're going to operate. We know sort of why they were passed and what the intent is, but there's a lot that remains to be seen. So now let's talk about what we do know about the courts based on the enabling statutes. First, the judges. I think at least what a lot of folks in my world are talking about is that the success or failure of these courts is going to depend on the jurists that actually end up taking on these roles. So unlike our existing courts of general jurisdiction, where the judges stand for election every 4 years and they're elected on a partisan basis, the judges who will be filling the business court will be appointed by the governor, and they'll be appointed for 2-year terms. Now, that does suggest a little bit of volatility in the sense that it's not, unlike federal judges who are appointed for lifetime terms, these judges will only be appointed for 2-year terms. This is a little bit of a, I think the legislature did this to as sort of a loophole in the sense that there are some constitutional issues under the Texas Constitution if the judges were appointed for any longer than 2 years. But the messaging behind this was that the governor intends to appoint judges on a 2-year term and that those judges should be reappointed for some longer period of time to give the court some stability. Now, it's an open question as to whether that will actually happen, right? The business court itself will have up to 15 judges. The initial appropriation in the enabling statute includes funding for 7 judgeships. The full court will include 2 judges in each of what I think of as each of the 4 major cities in Texas: Dallas, Houston, San Antonio, and Austin. And the remaining judges will cover other geographic areas that are divided into judicial administrative divisions, for a total of 15 judges. In the initial instance, we're going to have a judge in each of Houston, San Antonio, Dallas, and Austin, with the other 3 judges spread across the state. Each of these judges, as I said, will be appointed by the governor. And to be a judge, the statute requires that the individual have 10 years combined experience with some combination of commercial litigation, commercial transactional experience, and other experience as a judge. And the idea goes to what I was saying originally, is that the idea is to have judges on this court who have the necessary experience to deal with some of the more complex commercial disputes that exist and that are ongoing within the state now, and that we expect to continue into the future. In terms of jurisdiction, the business court will be a court of limited jurisdiction, and the statute provides some specific guidance on this, in that the court is designed to hear corporate governance disputes that exceed $5 million in controversy. So this is any dispute arising under the Texas Business Organizations Code. So I think back to law school corporations class, where I was dealing with Delaware corporations and shareholder litigation. If that exists for a Texas company and the amount in dispute is 5 million or greater, then the business court will have jurisdiction to hear those disputes. That also would cover any kind of partnership dispute, some kind of claim for breach of fiduciary duty under the LLC Act, things of that nature, or any other claim under the LLC Act or the Texas Partnership Code or the Texas Corporate Code. The court also will have jurisdiction over any dispute that involves $10 million in controversy where the parties have consented to jurisdiction. So this plays a little bit into what we're going to talk about in the second half of the presentation. But if you have a transaction that involves substantial consideration, and you have agreed with your counterparty that any disputes should be resolved in the court, the business court, the enabling statute specifically allows for jurisdiction in that instance. So if it's a supply agreement, if you're dealing with some kind of financing agreement where you otherwise wouldn't have jurisdiction tied to the Business Organizations Code, you can still almost create business court jurisdiction to address those kinds of disputes. And the third area of jurisdiction that the court has will be over disputes arising from qualified transactions under the Texas Business and Commerce Code and the Texas Finance Code that involve over 10 million in consideration. So if it is one of those qualifying transactions and the consideration exceeds 10 million, the court would have jurisdiction even if the parties didn't expressly agree to that jurisdiction in the parties' agreement. The court also will have supplemental jurisdiction over related claims. So where this might come up is if you have a breach of fiduciary duty claim against a corporate director or an officer and it exceeds $5 million. And so you've triggered one of the areas of the court's general, areas of jurisdiction. And the director or officer has countersued for breach of an employment agreement, right? The court would potentially have related jurisdiction over that claim. Or if you have a breach of fiduciary duty claim against a corporate director and officer and you have a fraudulent transfer claim, there potentially would be related to jurisdiction. The catch with the related jurisdiction is that it is still fairly limited in that the related jurisdiction would only apply if both the parties agree that the related claim should be heard in the business court and the judge overseeing the case, the business court judge overseeing the case, consents. So the related to jurisdiction is not automatic as it is in certain circumstances in federal court. And notwithstanding the ability for the court to have related to jurisdiction over the kinds of claims that I just described, it expressly cannot exercise jurisdiction over claims involving medical malpractice or personal injury or legal malpractice, regardless of their relationship to a claim within the business court's jurisdiction. I think the intent here, aside from whatever, I won't get into whatever kind of political motivations and lobbying motivations might be out there, but I think the intent here is to leave the cases with the courts of general jurisdiction where those courts have the expertise and the resources to handle them, and isolate the cases that involve the truly complex commercial issues that were sort of the reason that the legislature created this court in the first place, right? So I mentioned how one of the frustrations that I have when dealing with a complex commercial dispute isn't necessarily with the quality of the judge in the abstract, but it's that my case has such a different character than the personal injury cases that the court is also handling at a much higher volume basis. And so it's difficult to sometimes get the kind of attention that I would like to get for my case in front of those judges, because they lack they can lack the resources to appropriately resolve them. In terms of procedure, there are a couple options for getting into the business courts. And as you might imagine, plaintiffs and defendants, depending on the circumstances in a case, might have a different view about whether their case should be in business court or whether it's advantageous from their position for it to be in business court. A plaintiff can file directly in the Texas business court where business court jurisdiction exists. Now, the business courts will have concurrent jurisdiction with courts of general jurisdiction. And what I mean by that is that just because the legislature created these courts and gave them jurisdiction over the kinds of complex disputes that I described, it hasn't taken away jurisdiction from your courts of general jurisdiction. So a plaintiff can choose, if business court exists, similar to how a plaintiff can choose whether to file in state or federal court in the first instance if concurrent jurisdiction exists. A plaintiff can choose whether to initiate their dispute in either business court or in the court of general jurisdiction. Now, again, like in federal court, defendants have the ability to remove a case to the business court where jurisdiction exists. And I will admit that the jurisdictional outline of what the court can handle, and particularly the nuances of related to jurisdiction, it's not that they're unclear, but it's somewhat complex. And because of that, and because of this additional removal procedure, I think it remains to be seen, and we'll see how this actually plays out when the courts begin operations next fall. But I think we can probably anticipate that there will be some significant procedural litigation related to whether and to what extent the business court should exercise jurisdiction. And for those of you who have been involved in complex multi-jurisdictional litigation, I also think that this can potentially present some issues around how anti-injunction principles will affect parallel litigation, or whether any abstention doctrines might apply when you have related claims pursuing in different jurisdictions on a parallel track. I think we can probably expect to see some significant litigation in that space, which for me, I think would be interesting, but maybe not so palatable from a business and commercial perspective to see these issues play out. One significant point about the Texas business courts that I haven't yet talked about is that the business courts will allow for jury trials. And to the extent you have a right to jury trial under the Texas Constitution under any kind of claim, and our right to jury trial under the Texas Constitution is actually more broad than it is under the federal Constitution. But to the extent you have a claim that involves a right to jury trial, the business courts preserve that. And you'll be able to have your case tried to a jury in these courts. And the reason I emphasize that is a significant distinction between how these business courts, how we think they're going to look. And I think, a different jurisdiction or different forum that a lot of folks are comparing the business courts to, which is the Delaware Chancery Court. In the Delaware Chancery Court, you cannot have a jury trial because that's a court of equity, obviously, that does sometimes resolve legal claims that are related to equitable issues, but there are no jury trials in the Delaware Chancery Court. And I think strategically, depending on what kind of contract you have, what the subject matter is, where it is, where your business is, that's an important, I think, distinguishing factor. So now let's talk about the practical implications, and I'll now turn it over to Catherine.
Perfect. Thanks, Ben. So, as Ben's been discussing, and as he kind of hinted to earlier in the presentation, these new business courts are going to have a direct implications on business transactions. And obviously, we can start thinking about that just a little bit. Looking at how the Delaware Chancery courts have played out and worked for over a century, the popularity is there for a reason. And so we're kind of taking a look at those courts to see kind of how our Texas business courts will function. So just kind of generally the Texas courts right now, the general jurisdiction, Texas courts, our statutes in Texas do not, expressly emphasize the freedom to contract as they do in Delaware. So there's a little bit more of a question. We rely on the courts in certain instances. More than they would in Delaware in certain cases. Ben mentioned litigation that would be seen in these courts arising from fiduciary duties. That's one place, where there could be a little more clarity in Texas, particularly as it relates to member-to-member fiduciary duties in Texas. There have been a couple of instances in appellate courts where they have kind of provided a bit of guidance on that, but there is a long line of kind of some varying ideals on how member-to-member fiduciary duties play out. And so, just generally, there will be a greater certainty over corporate matters than there is at this point in time.
Yeah, and that's a great point, Catherine, because when I'm talking to people about Delaware, or at least in my mind, it's not that the law in Delaware is better. It's that it's better developed, which leads to greater predictability. And so one of the issues with our courts of general jurisdiction is that, as I was talking about, they have such constraints on their resources. They don't issue written, reasoned decisions in trial matters. And one of the benefits of being in Delaware is that there's a well-developed body of case law coming out of the Delaware Chancery Court, right? And we're anticipating that the Texas Business Court will be issuing written, reasoned decisions that will help give us some more guidance around the contours of these issues that Catherine mentioned.
That's exactly right. There's so much thought in Delaware that you can kind of directly go to a written opinion and see exactly, guidance on a particular principle of law. And so that's something that, Texas will be able to adopt with these business courts. There's also, different interpretations of Delaware case law. There's a recent case I've put up here on the slide, Condon CKC versus Kadakia. This involved a couple of JV partners. They were members of the JV, and one of the partners had signed they had the JV had signed an agreement with a royalty, an entity that was creating royalties for the JV. And so there was some of the facts allege that one of the partners in the JV began kind of, forming another company that was directly competing with the royalty creating entity, as well as, using that company to discount fuel greatly. He was also involved in the company that was creating the royalty payments. And so there was, decision within the court that this was not, that this didn't meet the business judgment rule test, and that the plaintiff had not pleaded with particularity enough to pass that business judgment rule test. But there's a particularly insightful dissent in this case where, the justice felt that the court had kind of conflated the idea of independent directors and independent officers versus interested independent directors and officers. And there's a pretty bright line test in Delaware, just given the case law and given the precedent in the Chancery courts that speaks to the independence versus interest or director test. And so, there was a bit of thought that perhaps the court got it wrong in that case. And so this is something else where we're hoping, when we have a business court with experienced judges who are very well-versed in business litigation matters, that there will be more of a coherent applicability, particularly of Delaware law, given that so many contracts will be governed by Delaware law. So a little bit of kind of what we've been alluding to here, just like what we can glean from the Delaware Chancery courts as it relates to the Texas business courts. They're well-established courts. As Ben mentioned, a lot of the desire to litigate in Delaware doesn't necessarily have to do with the favorability of the law, but it's more of the just like the consistent applicability. They have over a century worth of, kind of precedent out there. So you know what to expect. There's limited subject matter jurisdiction, just like there will be in the Texas business courts. The thought there, which Ben spoke to earlier, is that this will create expediency. It certainly does in the Delaware Chancery courts. There's more expediency. There's more, it's only seeing business claims and business litigation. And so it creates more of a streamlined process there. The chancellors and vice chancellors are, very well versed in, business. Just to kind of like demonstrate that a bit, Vice Chancellor Travis Laster, who is one of the longer serving chancellors on the court, he was a founding partner of a corporate law firm which specialized in high stakes litigation involving Delaware corporations. There's a couple of newer chancellors on the court as well. Vice Chancellor Lori Will, she was a partner before becoming Vice Chancellor. She was a partner at Wilson Sonsini, and prior to that, she was at Skadden. So she has a very, well-versed idea and experience with high stakes commercial litigation as well. Then, Nathan Cook, also a newer justice who has served since 2022. He was the managing partner of a Delaware-based firm, and he focused on his litigation on practice in the Chancery courts. So it's expected that, the justices will be very well versed with business matters, which will create, speaking to the previous slide, which will create, more of a streamlined approach to applicability of the law. So here's kind of what we've been discussing, and just we won't hammer the matter in too much more, but just streamlined procedures will have improved certainty. I think one of the biggest kind of exciting, I guess, for a lack of better words, for the legal nerds, is the written opinions. I think it will be very helpful to be able to look at a written opinion, know exactly where the law is leading, kind of touching on the fiduciary duties matter. Delaware has, extensive case law on Delaware fiduciary duties, kind of a chain of, various tests and whatnot. And so it's very easy to take a look at that precedent and know exactly what to expect. It's also thought, has been mentioned with the supplemental jurisdiction, with supplemental issues governing, or that are involved within the transaction, or, the transaction, even if there's not jurisdiction in the business courts over the supplemental issues, if those are heard, then there will be even greater clarity arising from the fact that the business courts will have heard those supplemental issues as well. These courts are going to be very new. And so, early litigants who are in these courts, I think will get a great chance to kind of affect the development of the law, and be heard, in a certain matter, and be able to kind of guide how they would like the law to kind of evolve. Later litigants will just have really great, robust, developed precedent. So I think there's definitely going to be advantages to kind of both sides of the coin there, being heard early or later in the business courts. So now we wanted to just touch briefly on some drafting considerations. As we've kind of hinted, this is a good time to kind of come back to, the drafting, knowing about the how it'll affect being in the business courts. I think okay, there we go. So, I think just kind of touching briefly on immediate next steps. I mentioned that, we think early litigants will have an opportunity to really kind of develop some of the precedent. I think in the meantime, especially for equity-based transactions, equity-based agreements, commercial agreements, we think that it's probably best to continue using choice of law and governing law, and venue in Delaware, New York for loan agreements, things like that, just while the courts are getting up and running. It's a little too early to tell how the precedent will develop. We certainly, as we are today, can kind of guess and predict how that will go. But we do have a lack of precedent at this point in time. And so it's probably best to just continue using Delaware and New York as we kind of watch the Texas business courts evolve. The one exception we will say is for commercial and operational agreements and asset level purchase agreements in the energy space. It is certainly more favorable to use Texas as a venue in governing law in that instance. Just generally the case law in Texas is certainly more favorable. And so it ends up making the litigation arising from any of those agreements much more predictable over ownership, mineral rights, certain assignments, seismic data and whatnot. So the kind of takeaway here is that we'll continue monitoring how these Texas business courts develop. And, in the future, it may be more favorable to use Texas law, even for equity-based agreements. And perhaps that it would be, more, it would be easier and more convenient for litigants based in Texas to be able to litigate in the Texas business courts. Another thing that Ben talked about earlier that we'll want to monitor as well is just kind of how the jury issues play out in the Texas business courts. This is a pretty large deviation from how the Delaware Chancery courts work. And so we'll want to kind of determine how the jury issues play out, how the cases that are heard in front of a jury go, and whether it would be favorable to either waive the jury trial or continue to be heard in front of a jury. So some general drafting considerations for forum selection. These are a little bit broadly just kind of a general reminder for forum selection clauses. You know, even if you're not drafting for the business courts, you know, you want to make sure that the forum that is selected is reasonable. Because, you know, forum selection clauses, believe it or not, have made it to the United States Supreme Court, and they need to be reasonable under the circumstances. You know, depending on whether there's jurisdictional problems, whether it's inconvenient for the parties, you know, neither of the parties have any type of connection to the forum. You know, it needs to be reasonable. I will say, however, there is a pretty high burden to prove that the forum selected between two parties in a contract or an agreement is in fact unreasonable. So generally, if the parties have agreed to litigate in a certain forum, that is respected by the courts. But just to keep in mind that it should be reasonable.
Yeah, and just a little war story, I guess, on this one. It is possible to contract your way out of access to the courts. And I'll share kind of just high level an ongoing case that I'm aware of, in which the forum selection provision requires the parties to litigate in a specific federal district court. Now, the problem with that, as many of you may know, is that you cannot create federal jurisdiction by agreement, and a federal court is not allowed to hear a case over which it does not have jurisdiction. But because the parties agreed to exclusively resolve disputes in front of that federal court, a state court has made an interim ruling in an ongoing case that I know of, in which the state court has refused to hear the case based on the parties' forum selection clause. And we're, you know, it's an open question what the federal court will do with it. I mean, it's kind of an academic issue in some senses, but in other senses, it's a very practical and an important issue, depending on how this case plays out.
Yeah, so that's a really good indicator that these forum selection clauses are very important in contracts. And I know oftentimes when we get to the miscellaneous sections, we just kind of throw them away. And so, you know, a good reminder that they can play out in court. They, you know, on the same note, they really need to be clear and unequivocal. It needs to be very obvious where the parties are choosing to have any cases heard. And, you know, our recommendation here, you know, in terms of if you're wanting to have anything heard in the business courts, is to make sure that you encompass, you know, supplemental jurisdiction. So making sure that any claims related to the transaction are heard in the business court. There's also some kind of, you know, speculation as well. Their business courts, there will be 11 divisions of business courts, but the governor can't appoint judges to 6 of those until July of 2026. And so there is a probable likelihood that there will not be operating business courts for a bit in certain of the jurisdictions. So, you know, if the parties are desiring not to, you know, litigate in a business court, they could choose a jurisdiction where there is not a business court, because you will be unable to remove a case, you know, from a district or a county court where there's not an operating business court into a business court. So that's also something to pay attention to when you're drafting agreements. If there is a desire to be able to remove to a business court, just ensure that you have, you know, your jurisdiction is in one of the 6 counties where there will be early business courts and judges appointed to those. So here we have just kind of an example forum selection clause. Won't necessarily read the whole thing, but wanted to just point out, where you would have, that the parties submit to the exclusive jurisdiction of a certain court, a federal court or a state court. We want to there include that the parties submit to the exclusive jurisdiction of the business courts located in, X county or in Dallas, Texas, wherever the business court is that you would like to litigate in front of. And so we want to make sure that it's an exclusive forum selection clause, just to make sure that it's ironclad, very airtight. But this is probably something that folks have seen before, but, just to make sure that all the bases are covered, you also want to make sure you say that if the business court ends up not having jurisdiction, you are also choosing the court going from that point forward. So also, we've gone from the business court, if there's no jurisdiction over the business court, in the federal courts located in a certain county. And then if the federal courts don't have jurisdiction, then in a state court located in a certain spot as well.
Right. So applying this to the example that I gave, I think probably what the parties wanted was to have a provision that said, if federal court jurisdiction exists, that's where we want to be. But then they left out the part 2 of what Catherine's talking about, which is in the event federal jurisdiction does not exist, then this is the state or other venue where we would like to have this matter heard.
Yeah, so just really making sure, you want it to be a simple clause. You want it to be very, concise and precise, but you also want to make sure that all of your bases are covered and make sure that you have, backup plans, essentially plan A, B, and now C as well. So, just drafting considerations, this is for more of a dispute resolution, kind of thinking of this in terms of purchase price adjustments and how the disputes are resolved there, or if you have any type of other dispute resolution where the parties are able to kind of determine whether they come to litigation. Simpler is better. We want to avoid kind of any unnecessary steps between attempting to resolve the dispute and proceeding to litigation. This again, I think it just helps, eliminate any unnecessary kind of language around what would happen between the parties, and kind of speaking to Ben's example, making sure that everything is, all the bases are covered. So we've kind of, we put here, an example, if the matter hasn't been resolved within 45 days of disputing the parties' notice, then either party may initiate litigation within 20 days upon written notice to the other party. We would really suggest that just either party may initiate litigation. In practicality, in reality, the parties are going to discuss with one another and, determine whether litigation will be initiated or not. And so just kind of cutting out kind of some of the underbrush and moving directly to the point.
Yeah, and I think when people negotiate terms like the one that we're saying not to include, the intent is always, okay, well, let's be commercial about this. I don't want to be in litigation, so let's figure out a way for us to be able to work through problems without heading straight to litigation. The practical problem that I can speak to as a trial lawyer is that by the time a contract ends in my lap and someone's in that situation, it's sort of that sort of becomes a moot point at that point, right? And hopefully even after I get a file, we can try to figure out how to resolve it without heading to court. But all I'm saying is that, the parties have, hopefully by the time I've gotten involved, already exhausted a lot of their, non-litigation options. And what these complicated dispute resolution provisions do is they tend to create satellite litigation over whether you complied with your dispute notice requirements or whatever the case may be. that actually gets in the way of resolving the issue. Because if you need to be in court, you want the arbitrator or the judge or whoever to be focused on the substance of the dispute and not whether, you sent your dispute notice on the right kind of letterhead, or like whether you were supposed to send it certified mail and you sent it FedEx or whatever, right? So.
Yeah, don't want to get bogged down by trivial logistics. So drafting considerations for governing law provisions. There are certain reasons that Texas governing law would be favorable. Kind of mentioned earlier, the asset level purchase agreements, commercial and operational agreements as well. But, for certain reasons that, plaintiff recovers the attorney's fees for a successful breach of claim contract. That's obviously, that kind of speaks for itself, and that, hearing your case in Texas might be favorable in that regard. Fraudulent inducement claims are defeated by the disclaimer of reliance provision, so you can contract out of those. There's not an applied covenant of good faith and fair dealing. This is really, it's only in cases of special relationships, which there's certain precedent in Texas kind of governing which relationships constitute special relationships. And then there's very reasonable limitation periods. So, particularly in the case of asset purchase agreements and the ones that we've mentioned, Texas law can certainly be more favorable there. As kind of touched on earlier as well, Delaware and New York law are probably the way to go at the moment until we get a more robust set of precedent from the Texas business courts, particularly for, debt instruments, equity level purchase agreements, things like that, just given the amount of case law that we have in Delaware and the amount of kind of certainty and precedent that we have there. All right, and we wanted to save some time for questions. And I think you all can enter any questions that you have in the chat, and we'd be happy to answer and take any questions on what we've discussed today.
I'm not sure if everyone can see, so I'll read the question. The question is, will business courts deal with Delaware corporate issues or only Texas organizational issues? So I view this as sort of procedural versus substantive dichotomy here. So the jurisdictional statute that I was talking about gives the business court's jurisdiction automatically over cases involving the interpretation of the Texas Business Organizations Code that exceed $5 million in controversy. That doesn't mean that the court will have to or will be restricted by those issues. So, in Texas courts now, you can file a case if the Texas court has jurisdiction and there's no requirement to proceed in Delaware. You can still file a case involving a Delaware corporation, and the Texas court is supposed to apply Delaware law. And I think the converse is true in that you may have an agreement that requires adjudication in Delaware courts or New York courts or whatever, where Texas law might apply. Now, there are pros and cons to doing that. Personally, if I'm a Delaware corporation and I know it's going to be Delaware corporate law issues, I probably want the Delaware Chancery Court to weigh in on it. Although I could see a situation where, maybe from a corporate governance perspective, I want those issues to be resolved in the Delaware court. So I think about like our private equity clients, so our fund clients or kind of top level organizations, maybe stick with Delaware and New York, and Catherine will correct me if I'm saying something wrong. But if you're talking about, portfolio company issues that involve assets or Texas specific issues, maybe have their commercial agreements focused on Texas law issues. Or if for some reason you're setting up a joint venture that's a Texas LLC or something like that, you may want to have the Texas court weigh in on those issues. But I don't think that means that you can't litigate Delaware law in Texas court or vice versa. That's just sort of the way I think through it practically. We have another question, which is it advisable to specify venue in one court if the claim predates the opening of the business courts and a Texas business court once they are operational? Yes, I think that's a smart way to think about this. The one caveat I would have is that, we're really optimistic about what these courts are going to be able to do. I hope this isn't the case. I don't think this is the case. But if the slate of judges that are appointed and start operating the court next fall are not, great for whatever reason, you may not want to sort of hamstring yourself to that before we really have a better sense of how the court's actually going to function. But yes, I think if you're negotiating an agreement and you want it to be resolved in Texas courts, and if you want, if it's the kind of dispute that should be in the business court once the business court's operating, then I think that's a very smart way to approach it, personally.
Yeah, absolutely. I think that kind of goes back to the topic that, making sure it's very clear where you want your dispute to be heard. Just being very precise about it. So agreed. I think that's a great approach to take, just so that, it's very clear that if the business court is open, you want your case to be heard there.
And we have another follow-up question, which is, can you choose any of the districts, or do you have to have a presence in the district? In looking at the statute, I believe that the normal venue rules under the Texas Civil Practice and Remedies Code will apply here. And so the same way that I can agree to have a dispute heard in Harris County, Texas, I think I could agree to have a dispute heard by the business court that, whose geographic area includes Harris County, Texas.
All right. Looks like that might be all the questions, but we're also happy, to answer anything after the presentation as well.
Absolutely.